Welcome back to the Politics with Paul podcast, your home for nonpartisan discussion of political science and civics. I'm your host, Paul Rader. Today, we're going to talk about how to interpret laws and legislation. Do your eyes glaze over whenever you are trying to make sense of legal text and information? Or do you really want to know how to understand legislation, but you don't know where to begin, or you're just overwhelmed by all the jargon? Well, you're in luck today, because today I'm going to give you a crash course that introduces you to the world of interpreting laws and legislation. A lot of this actually comes from a webinar I do for civics and public affairs and nonpartisan organizations about helping themselves and their clients better understand legislation, particularly ones that they have a vested interest in or against. And that webinar goes much deeper into the weeds, so I'll plug that as well. And I had an episode early on in this podcast history that talked about how people interpret the U.S. Constitution. And we will, of course, go into that, but some of that content, while it is in today's episode, will improve upon that information that was over a year ago now and go into some more info that is relevant. And we're also going to talk about how to interpret federal statutes and state statutes as well, along with why this stuff is important to know. But as you'll see today, there is a sort of through line between old debates about how to interpret the U.S. Constitution and how to interpret federal and state statutes today. So I'm going to start with those early constitutional debates and then work the way down. It'll make sense at the end. And then at the end, I will talk about why this information is practically useful, even if you might not realize it. So, let's go. First of all, the origins of constitutional interpretations, particularly when it comes to implied versus enumerated powers. So after the U.S. Constitution was ratified, the debate over its interpretation, well, it was by no means over. It had, in some ways, only just begun, particularly over how stringently we should adhere to the words of the Constitution. And so this is where this debate between particularly implied versus enumerated powers enters. So implied powers are, they're implied, powers that are not explicitly stated to belong to the federal government, but considered necessary for its function. And the chief source of justification for people who advocated for implied powers came from what is called the necessary and proper clause, which is that Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. And then on the flip side, you've got enumerated powers. They are enumerated. They are explicitly laid out to be legal and belonging to a particular government official or body. So it might say that X power goes to president, Y power goes to Congress, Z power goes to the Supreme Court or federal courts in general. And the chief source of justification for this comes from the 9th and 10th Amendments to the U.S. Constitution. The 9th Amendment says basically that all rights that are not expressly denied by the U.S. Constitution are given to the people. And then the 10th Amendment says powers not given to the federal government belong to state governments. So, who supported which kinds of powers back then? This was before we had the Republican versus Democratic schism, if you will, that we see today. And technically, actually, the Democratic Party existed then in a different form, but we'll get to them in just a moment. Implied powers were predominantly supported by the long since defunct Federalist Party. The Federalist Party was born from early supporters of the U.S. Constitution replacing the Articles of Confederation. When the U.S. Constitution was being debated, not everybody agreed that the Articles of Confederation needed to be completely thrown out. Some people argued that it should simply be revised, and that's initially what the Constitutional Convention was under the guise of, and then a lot of people got very upset because these Articles of Confederation were getting thrown out wholesale. But for people who supported implied powers, particularly Federalists, they felt these powers were necessary to invigorate the federal government following the very weak central government from the Articles of Confederation. So that whole necessary and proper to help the federal government execute its powers. And then on the flip side, enumerated powers were predominantly supported by the Democratic Republican Party, who is the Democratic Party of today. They were born out of the anti-federalists who opposed replacing the Articles of Confederation, but they slowly started to become accepting of the Constitution. And they felt that these enumerated powers were necessary to keep the federal government in check and keep the states' rights intact, given the states' time as colonies under the British Crown's strong central government. And so they were very concerned that the necessary and proper clause in particular would lead to federal government overstepping its bounds. Perhaps ironically, though, the Federalist Party would cease to exist by the 1820s, and the Democratic Republican Party was the earliest iteration of today's Democratic Party. And actually, in some cases, Democratic Republican presidents would use implied powers to do various things, like, for example, Thomas Jefferson and the Louisiana Purchase, which basically doubled the size of the United States at that point. He was actually not sure that the Constitution gave him any power to make that decision, but the implied powers doctrine, if you will, was used to say, okay, you know what, this needs to be done. We're going to buy this giant tract of land for a really good price then. So you're about doubled the size of the United States at that point. It was for, I think, $25 million then, which was a pretty good deal. But in any case, that just demonstrated how there was that debate between enumerated and implied powers. So, like I said at the beginning of this episode, there's a sort of through line from the debate between these old constitutional arguments about enumerated and implied powers to today's debates about how to interpret the Constitution. It doesn't quite use the same terminology as enumerated and implied, but you can see some certain parallels. And the easiest way to think about this is that there are two, technically three, but I'll talk about that in a moment, but there are technically two basic schools of thought about interpreting the U.S. Constitution. On one side is originalism, and then the other side is living constitutionalism. And originalism has an offshoot that sometimes conflicts and sometimes coincides with it, called textualism, but that will appear in the next section that we talk about. So we're going to look at this dichotomy between originalism and living constitutionalism and showcase several of the key arguments for and against both. So originalism basically says that the words of the U.S. Constitution should be interpreted in the way that they would have been interpreted in the time of the framers of the Constitution. And you sometimes hear this called original intent. So whatever the founding fathers meant, that's what we got to go with. It does not change throughout history, the meaning of these words. Doesn't that sound quite a bit like enumerated powers? Not entirely like enumerated powers, but it's looking to what the framers meant by the text, want to look at things that they explicitly said in text, which is a lot like enumerated powers, which talks about what is explicitly said in the text. If it's not outright stated, then it's not constitutional, basically. And then on the other side is living constitutionalism, which basically says that the meaning of the Constitution evolves over time to adapt to new challenges and changing values. And sometimes that refers to the Constitution as a quote-unquote living, breathing document. Doesn't that sound a lot like implied powers? Because for the Constitution to evolve, there has to be some level of implication to find in text to say, well, this is what the Constitution would have said about insert current challenge or change societal value if it was being written today. Or if the founding or the framers of the Constitution were writing it today, this is what they would say. But like any other ideologies or theories, there's going to be some flaws in them. So let's talk about arguments for and against both originalism and living constitutionalism. So key strengths or arguments that are made in favor of originalism is that the framers were the original source for the meaning of these words. Obviously, we're trying to figure out what the framers meant at the time that they wrote these things. That has to be accounted for in some way. Number two is that the framers were very prescient about issues with governance that could crop up after a time. I mean, The U.S. Constitution still stands a good 236 years on. 1789 was when it was completely ratified. So there had to be some level of foresight from the framers of the Constitution. And then number 3, it's important to look to the past for some guidance on the present and future. One of my guests that I had recently on the podcast here, Crom Carmichael, we kind of talked about that idea a little bit, about how to look to the past for guidance for the present and the future. But on the flip side, some of the weaknesses that some people will point out in originalism is that for all their prescience, framers couldn't account for everything that could possibly crop up after their time. They were only human, and no matter how prescient people are, your foresight is only going to be able to go so far. There's all sorts of issues that the framers could not even dream would come up, although they knew that some things would come up. They just didn't really know what they were. Number 2, some people argue against originalism. Even the framers and the early statesmen of the United States disagreed on the meaning of the Constitution, and they didn't get everything they wanted. These constitutional debates, the Constitutional Convention, which actually went on for several months and over several meetings, there was a lot of sharp disagreement about what to put in the U.S. Constitution. So some framers can have different intent behind different words. And then number 3, the Constitution is somewhat vague in many respects, and thus can make it more difficult to establish framers' intent. And to some extent, that was necessary to actually get constitutional passages implemented, is they only could be so specific because some of the framers said, no, we don't like that. It should be said like this. So sometimes they had to make things a little bit more ambiguous, especially if you compare it to federal statutes and state constitutions and state statutes. The U.S. Constitution is not very specific about a lot of things. It's actually not a very long document at all. I want to say it's something like 7,300 words for a defining document of what U.S. law is supposed to be based on. It's really not a whole lot to it. So that also throws a bit of a monkey wrench in it, if you will. And then arguments for and against living constitutionalism. So some of the key strengths or arguments that people will point to for living constitutionalism, and to some extent these are the inverse of the arguments for and against originalism. So some of the key arguments that people make for living constitutionalism is that the framers could not predict everything, so you need this document to be adaptable. If you can't possibly know everything that's going to come up, you can't necessarily write rules for every single situation. So you need to be able to adapt as time goes on, as new challenges crop up, as societal norms and values change. Number 2 is that the Constitution was meant to not be too strict in meaning so that it could adapt and enough of the framers could agree on the document. Otherwise, the Constitution would not exist. And then number 3, the Constitution had some notable flaws in its past that had to be corrected. We particularly look to race, for example. Even though the transatlantic slave trade was eventually outlawed in 1818, I believe it wasn't outlawed immediately. You still had the 3/5 compromise, which counted every slave as 3/5 of a person for the purposes of the census, instead of what slave owners would have wanted is for one whole person, or for people who were not slave owners who opposed slavery was for them to not count for the purposes of a census, and in a lot of cases wanted to abolish slavery outright, but slave owners wouldn't be going for that. So unfortunate flaws that were not rectified until the Civil War happened. But so you had a lot of these issues in the U.S. Constitution, and just like any other document or thing created by humanity, there were flaws into it. So we can't treat the original meaning of the Constitution as perfect. Now, on the flip side, some of the key weaknesses and arguments against living constitutionalism is that if you take it too far, it could easily go too far by becoming an excuse to interpret the Constitution the way that one sees fit, which would make the document ultimately meaningless and can threaten people's rights. If we can just make the Constitution say whatever we want and change it to according to our whims, then why do we even have the document in the first place? So that also accounts for, or doesn't account for, but it also brings up the problem of people. We all have our biases, and a lot of times we say the Constitution means what we want it to say. We don't necessarily actually try to look at it through an unbiased lens. Another argument against living constitutionalism is that it can ignore the valuable perspective that the framers had and continue to have for today's problems. After all, this document has been going on for 236 years and still around and has been amended 27 times, but considering how long it's been around, that's not really many amendments in general, and we haven't had an amendment since 1992, I believe was when the 27th Amendment was ratified. So, obviously still not a perfect document, but still incredibly valuable, and a lot of it is still intact today. And then number 3, the Constitution isn't as vague as some political observers would argue. There are, as the enumerated powers would suggest, there are a lot of things that are specifically stated in the U.S. Constitution. There has to be some sort of baseline that we can agree on and say, okay, this is definitely what the Constitution says about these things. So, originalism, living constitutionalism, both have their pros and cons. Which one's the quote-unquote best one? That's for you to decide, but this is just really to lay out the arguments that people make for and against, because I try to make these debates as even as possible for people to decide, give you the arguments that people make for their side and for against the other side. But you can still see these arguments about originalism and living constitutionalism, which are still things today, but you can see them in other legal theories and interpretive tools that we're going to talk about right now. So now we're going to be talking more about specifically reading statutes. Reading federal statutes and state constitutions and state statutes, but especially statutes at the federal and state levels. It's not quite the same as reading the U.S. Constitution or even the state constitution, but there are a lot of similar tools and arguments that you see, similar tools that are used, similar arguments that are made. And you can also see how debates about how to interpret the Constitution influence these legislative interpretive tools both directly and indirectly. And there's a lot of history of legal theory that we're going to be glossing over because it's not really necessary for the purposes of this episode, and I don't want to bog this whole thing down. This is more of a crash course into how to read legislation so that you can do it for yourself to some extent. But I'm going to draw some comparisons to these early debates that we just talked about with enumerated versus implied powers and originalism versus living constitutionalism. So there are two major overarching theories in how to read statutes. Not necessarily the only ones, but most can be incorporated into one of these two schools. So one is we call purposivism and one that we call textualism. You might remember textualism because I mentioned it earlier. Purposivism is the idea that interpretation should advance the statute's purpose. Basically, what was the statute made for? And this name comes from this idea that, quote, legislation is a purposive act, and judges should construe statutes to execute that legislative purpose. And so this focuses more on the legislative process, accounting for the problem that Congress or a state legislature was trying to solve and how the statute in question was meant to solve it. So you can see how purposivism reflects living constitutionalism and implied powers to some extent. In the case of implied powers, you're talking about interpretations that advance the statute's purpose. So you're using interpretations that are basically what is implied to be the statute's purpose. What is the statute implied to be trying to do? And in the case of living constitutionalism, one could say that advancing the statute's purpose can change and adapt over time. And then on the flip side, you have textualism, which focuses simply on what the text says. And I mentioned earlier that it's an offshoot of the originalist interpretive theory of the U.S. Constitution. It can actually butt heads with regular originalism because textualism doesn't care about the intent of the framers of the U.S. Constitution or the legislative body who wrote a statute. The two still generally align because it's still talking about like what was the original foundation of the text, but whereas originalism talks a little bit more about the intended original meaning from legislators, textualism just says we don't care about that. What does the text say, basically? And so it simply says to interpret the laws by the word's original meaning, and that's regardless of what the intent was. And some would say that it's what a quote-unquote reasonable legislator or a regular English speaker would think a statute's text means. So it's not nearly as concerned with context as purposivists are. So you can see how textualism reflects originalism to some extent, but also the enumerated powers to some extent, because you're talking about what the text explicitly says. Enumerated powers are talking about what the text explicitly says. But now if we go a little bit further into the field of purposivism and textualism, there are 5 main tools of legislative interpretation. And both purposivists and textualists may use any or all of these tools. How much weight they put on each one of them and which ones they use first can differ, but they can and sometimes do use all 5 of these main tools of legislative interpretation. For better or for worse, laws are not always straightforward and obvious in their meaning. A lot of times we'd like that to be the case, but the ambiguity can be intentional or unintentional. And also, certain lawyers get paid lots of money to find ways to interpret or even bend laws to what they want it to mean and what their clients want it to mean too. So there is that. But why, beyond that, why wouldn't laws be clear about what they mean? Well, a lot of it comes down to the realities of the legislative process with all the wheeling and dealing that goes on there. Legislators meticulously craft legislation and have to debate its provisions in committees and on House or Senate floors. Now, this is going to be oversimplifying it a little bit, but more vague bills can be attacked for being too broad, not strong enough. What do these words mean? What are the unintended consequences that can happen? So you can just look at that and say, well, why are there sometimes so many vague laws and legislative bills? But more specific bills can be attacked for being too narrow, not accounting for enough situations. The meaning of the words on there can also still be debated, and there still can be unintended consequences. So you make things more vague, they can be attacked. You make things more specific, they can still be attacked. And of course, the different situations can lead to different kinds of attacks and arguments. But even beyond that, laws can still get passed despite being sloppy and not well worded, whether legislators bring up possible issues or not, or if you have a legislature or a state government in general that leans heavily towards one party, and there's a lot of group thinking and hive-minded behavior, they probably will think, oh no, we got this figured out. We don't need to really actually account for anything else, and so they won't actually listen to arguments that are made, whether they are reasonable arguments against a bill or not. So you can still find plenty of sloppy bills or bills that are archaic but have never been actually addressed and updated and modernized. But also administrative agencies, which are in the executive branch, may also interpret laws in ways that a legislature did not intend, and how much leeway they have to do that depends. Now, at the federal level, we did see the Chevron deference doctrine take a hit, which the courts will, to some extent, defer to what administrative agencies interpret the law as long as there's some level of reasonableness to it. Now, at the federal level, that has taken a hit with some recent U.S. Supreme Court rulings, but at the state level, you might still see that kind of thing where a state level court might defer to a state executive agency's interpretation of a state law. But despite often being at odds with each other, like we said earlier, purposivism and textualism might use any of these 5 tools that we're going to talk about, but with varying order and weight put on each of them. So here are the 5 basic tools of interpretation that we can use for legislation. Number 1 is ordinary meaning. This is concerned with how words are understood in common speech and dictionaries, or if they have specialized meaning in certain fields. Number 2, statutory context, which looks at surrounding phrases in statutes and the overall structure of the law. Number 3, canons of construction, presumptions about how courts ordinarily read and interpret legislation. Number 4, legislative history, which is the record of a legislative body's discussion when enacting a law. There's a lot of meanings that you can refer to and other documents that talk about what legislators meant with a law. And then number 5, statutory implementation, which talks about how a law has been applied in the past and how it might be applied in the future. And all of them have their own strengths and weaknesses. Legal interpretation tool number 1, ordinary meaning. This is concerned with how a word is understood in common speech, dictionaries, books, databases. So if I opened Webster's dictionary or another dictionary right now and looked at a specific word in a statute, what does the dictionary say about that? Or what does a relevant database say about that? Or how do people just use a word in general? Or could the word have a specialized meaning in a particular field? So, for example, if you looked at state statutes or federal statutes, you might see the word corporation, which you tend to think about a big business. But it could also refer to a city, which can be called a municipal corporation. Or it might just be talking about maybe even a nonprofit is called a corporation. You sometimes might have to look specifically at what the state statutes say a word means, if that state statute even says what that word means. But speaking of which, in many cases, certain words in statutes will have a section in those statutes that define what the words in other sections mean. Not always, but it might have an entire section blocked off of, these are definitions for various words that you'll find here. And if you go to a statute that deals with that thing, it might tell you, go to section 100 to see what this word means, for example. And even if the word may mean something else in another context or in another state's laws, one state might have different stipulations for what that word means. If I were to use examples like artificial intelligence, we generally know what we mean when we say artificial intelligence, but in legal settings, it's not enough to generally know what you're talking about. So with the rise of artificial intelligence getting better and better and scarier, different states are talking about addressing artificial intelligence in different ways. Now, how that's going to butt up against the Donald Trump administration, who is trying to take a preemptive approach to artificial intelligence, that's beside the point. States might have different definitions for all the things that constitute artificial intelligence. Like if you play a video game, and you're one in particular where you kill things, which I like to do a lot of times. I like to play a lot of RPGs and first-person shooters, but that's technically artificial intelligence. But that's not the kind of artificial intelligence that people are typically talking about. You're typically talking about things like ChatGPT or anything else like that, or Grok for Twitter or X. Those are usually the kinds of things that people are talking about when it comes to artificial intelligence. So you might need to be very specific about the kinds of artificial intelligence that you are talking about, because AI is not a new thing. It's something that's been around for a while, but the kind of AI that we're talking about is a lot more recent. It's come up in the last few years. Another one is a monopoly. So you're talking about a monopoly. You're talking about a market where there's only one seller of goods. That you generally understand what people are talking about, but a state might write laws so that there's something that's akin to a monopoly. So they might say a seller that controls 70% of the market, where it's effectively a monopoly, even though technically monopoly has to have 100% of the market and be considered the sole seller of whatever the good is. Or you talk about a monopsony, which is the opposite end of the spectrum. Well, I don't know if it's opposite end of the spectrum, but it's where there's only one buyer in a market. So you might say where a buyer has 70% of the market or 60% of the market. It might be considered, he or she or it might be considered, if it's a business, might be considered a monopsony. Or what is a political symbol? Here in Florida, that has been a bit controversial, and because of a law regarding what political symbols can be displayed in public settings. And some people have argued that the pride flag constitutes a political symbol, whereas other people argue that it doesn't constitute a political symbol. So how do you define a political symbol in law? That is another major example of how you have to be specific about what you mean with a word or a term. But not everything in statutory law will be expressly defined, which is predominantly where this ordinary meaning interpretive tool comes in. So if there's no specific definition that comes into play, we say, okay, well, what does a dictionary say? What does an outside database say, or books, or common speech? Now, one of the big issues with the ordinary meaning interpretive tool is that a judge might invoke ordinary meaning, quote unquote, as a smokescreen to really just justify their own policy preferences, even if they don't intend to. Maybe they really think that this particular meaning of a word is ordinary meaning, but they either don't admit or they don't realize it's just their bias speaking. So ordinary meaning is not even necessarily agreed upon. Legal interpretive tool number 2, statutory context. So what do the surrounding phrases and the overall structure of the law say, or do they give any clues as to what a statute's meaning is? So you can talk about that if there is a section that talks about the definition of a word, or you can look at the surrounding clauses and other parts of a section and see what they might indicate about what a word's meaning is. Or is the term in the statute used elsewhere to indicate what that word means? A legislative body might have used different language elsewhere in a meaningful way, or use those same exact words in a different way in another passage in the statutes. Many statutes will be part of a much larger relevant passage. Not every state structures their statutes the same way, but a lot of them will follow a format that's similar to articles, sections, paragraphs. They'll say Article 1 is executive branch, for example. Then Section 1, 2, 3, 4, et cetera, will say different aspects that relate to the executive branch, like which agencies are part of the executive branch, which executive offices are part of the executive branch in that state. And then paragraphs might talk about more specific things, like this specific office is part of the executive branch. This specific agency is part of the executive branch. Or they might call the article a title or something like that. The verbiage might be a little bit different, but the basic idea is that's how state statutes typically structure themselves. There's other states that use things called state codes that are more divided by particular subjects instead of just simple 1, 2, 3, 4, 5, 6. It might be alphabetical, but that's a little bit beside the point. So if disputed language is used in another statutory provision, courts generally will try to give it the same meaning throughout statutes just for the sake of consistency. And that other provision might illuminate the meaning of what the word means in another provision. But an issue here is that if you find multiple instances of a term in other provisions of the statute, that can make the definition of a term rather murky. So if you have, let's use political symbol again. If you have political symbol in statutes, let's just say random number 20, and you see that word political symbol used in section 103, but they are two different, they're used in two different ways to mean two different things. Well, which of those meanings do you go with? That's not necessarily an obvious answer to that kind of thing. So you might have even more ambiguity about what a law means. And then that opens up a whole other can of worms, maybe even a dispute with another statute that uses that same word. Legal and interpretive tool number 3, canons of construction. So what is the general understanding of how a relevant court reads statutes? So if we talk about Michigan, how does the Michigan State Supreme Court or the appellate courts, how do they typically read statutes? And these canons of construction can serve as a guiding principle for interpreting statutes across legal disputes, though they might not always be applicable. So canons are more so presumptions rather than explicit rules. There's no rule book that Michigan justice has to look at and say, oh, okay, this is how we typically construct laws. No, there's presumptions that are made. So there are two main types of canons of construction. There are semantic canons and there are substantive canons. So semantic canons focus on text, grammar, and presumptions about legislative drafting. And these are especially favored by textualists because it simply focuses on the wording of the text. State legislatures often have a legislative drafting manual that legislators follow when crafting laws. And those are examples of something that could be looked to by the courts in the case of semantic canons. They can use that to help their understanding of, okay, this is how statutes in this state are typically crafted and interpreted. So one type of semantic canon is called a surplusage canon, which requires courts to give each word and clause of a statute operative effect when possible. So in other words, interpretation should not define a statutory provision in a way that renders it or another part of the statute inoperative, at least whenever possible. But an issue here with these kinds of canons is that some judges question whether a surplusage canon is even true, or if it is more or less likely that a legislative body even uses superfluous language. Once again, it's a presumption rather than an actual explicit rule, these semantic canons. And then you have substantive canons, which focus on the presumptions about particular outcomes that the legislative body would or wouldn't want. So it's especially favored by purposivists because it focuses on the statute's purpose and what the legislative body, whether it's Congress or a state legislature, was trying to do with a statute. And one type of substantive canon is the canon of constitutional avoidance, which says that if one reading of a statute raises, quote unquote, serious doubts about its constitutionality, a court should look for another, quote, fairly possible, unquote, reading that avoids constitutional issues. So if one reading suggests there's no way that this is constitutional, then you see if there is another reading that doesn't challenge constitutionality. So if we talked about political symbols again, is there a way to interpret it where it is infringing upon free speech in a way that violates the First Amendment of the U.S. Constitution, or is there a way that you can read it where it doesn't violate the First Amendment of the U.S. Constitution? But an issue here is that judges disagree on how much constitutional doubt should be present or whether an alternative reading is, quote unquote, fairly possible. Legal interpretive tool number 4, legislative history. So what is the record of a legislative body's discussion and deliberation when it comes to enacting a specific law? How can you discover evidence about the legislature's intent or support textual interpretation or understand a law's scope or some combination thereof? Well, there's several major tools that you can use to do that, which include recordings of committee meetings when they're trying to hammer out the issues with the bill so that they can ship it off to the full chamber floor, whether it's a House or Senate. You can look to written minutes of the committee meetings, which sort of like a text transcription of the committee meetings that you would otherwise get through video, or other reports by legislative staff, depending on the state. Some reports on legislation and what the legislation is trying to do and what are its predicted effects. Now, how many of these tools are readily available for state statutes depends on the state in question, because some states make it much harder to find recordings of the meetings. Some might live stream the meetings, but others don't. And some might have fewer reports on legislation and predicted effects than others. So using legislative history as an interpretive tool can be easier in other states than, or in some states than in other states. But an issue here is that legislative history can be conflicting, and it makes it difficult to determine which parts of the record should be heeded. Like if you talk about committee meetings and you're looking at a couple of legislators who disagree on a bill, but the bill gets passed through. So which of those intentions do we look at when we're talking about the ultimate intention behind legislation and the ultimate interpretation of legislation? Do we talk about that legislator who succeeded in getting that bill passed, or the one who was unsuccessful in stopping that bill? That is not exactly a straightforward answer. Legal interpretive tool number 5, statutory implementation. So how has a law been applied in the past, and how might it be applied in the future? So courts would investigate how a statute actually works, asking what problem a legislative body sought to address with the disputed provision, and how that body went about addressing it. So you can also look to statutory context to consider a law's operation. And courts might look at practical consequences to see if an asserted interpretation aligns with the statutory scheme. And they might also rely on their own understandings of how a statute is supposed to be implemented in order to interpret the statute's meaning. But you also, if you're a court, you might also look at administrative agencies' interpretations, because these administrative agencies are typically the first official interpreters of statutes, as they must resolve interpretive questions to carry out the statute. Even though Congress or a state legislature might have meant one thing by a passage, an administrative agency may look in and say, oh no, did they mean this? And sometimes, of course, they might have their own motives for interpreting a law, the way that they want to interpret a law, or if a governor is at odds with that state legislature, they might coax that administrative agency to interpret a law in a way that that legislature did not intend for it to mean. So you can see a little bit of that schism between executive and legislative there. So that's not necessarily a foolproof way of looking at things, because how the statute might be implemented in a state, it might depend on who exactly is in office. So that is one of the big issues there with using statutory implementation. So you see how each of these tools has its own positive things going for it, if you will. Some of these reasonable ways that it might be used to say, okay, this is a good tool to use in this situation, but just like anything else that involves human beings, they also have their own weaknesses and arguments that you could make against using them. And what interpretive tool is going to be used, or which ones are going to be used, and how much, a lot of it's going to depend on the judge in question, or the panel of judges, or the full court. Yeah, like if it's going in front of the Supreme Court, if it's going through an appellate courts might have panels of judges that look at it before it goes in front of that whole court. So you need to know which one of those interpretive tools is most likely going to be used by that judge. Speaking of which, why is it important to know how to read laws and legislation? Now, you've got this far. Maybe you already understand some level of the importance of how to read laws and legislation, but I think it still bears fully diving in case you start to think, well, is it really worth it to know these things? Or if you're trying to teach other people how to read laws and legislation, these are some of the reasons that you can use and should use to show people why these things are important. Because anybody can benefit from knowing how to interpret and read laws and legislation, not just people who are regularly involved in politics. Even if you're not, it's still very useful. So I'm going to talk about 4 main reasons why you should care about how to interpret legislation and why you should learn how to do it. Number 1 is that it enhances civic education. That might sound kind of obvious, but you gain a better understanding of how the government works, which inevitably impacts your life because, especially when it gets to state and especially local government, they have more and more direct impact on your day-to-day life, especially if it is a policy that you care about. Whatever policy it is that you can think of that you say, this is the thing I want to get involved in, this is the one I want to make a difference in. Well, guess what? Knowing how to read this legislation is important for you. If you want to change a law, or if there's a law that you really like, or a legislative bill that you really like, but you're trying to get it through to the finish line, you should know how these interpretive tools are used. And you're just better able to understand debates about laws, and we can have a better civic life in general for this country. A civic life that is very much, shall we say, not doing so hot right now. But of course, civic education is vitally important to upholding and promoting our democracy and our political way of life in general. Another reason why you should know how to interpret legislation is that it helps to incorporate as much info as possible to come up with the best solutions for a policy or governance issue. Nobody has all the answers. Some people certainly like to think they have all the answers. But when you get all these different perspectives, it helps find the shortcomings in a policy that can negatively affect citizens, whether directly or indirectly. The bad laws don't help out the general citizenry. There might be some special interests that benefit from a poorly written law, but overall, it doesn't really help people. So you should have some understanding of these different arguments so that you can look at legislation from various angles, even if it's one you support, and say, oh, okay, I see why somebody would think this is an issue, and you can fix those shortcomings accordingly. Number 3 reason that you should know how to interpret legislation. If you have any interest in getting involved in politics, or you're already involved in politics but you want to sharpen your skills, it always helps you to know how other people think. Not just because you're coming up with the best solutions for a policy, but if you are involved in a legal battle or you have a vested interest in a legal battle, you need to know not only your own arguments, but the arguments of the opposition so that you can more effectively counter what they argue. So if a piece of legislation or a bill is being sued in court, you need to know why people see that bill the way they do. Even if they have a misconception of the bill, you still need to know why exactly they think what they think and what interpretive tools they are using so that you can counter those arguments, especially if you're working for a client that is trying to get legislation passed or trying to save a law from being struck down by courts. And similar to what we call a SWOT analysis in a campaign. SWOT stands for strengths, weaknesses, opportunities, and threats. So in those kinds of campaigns, you look at, well, what are the things that about your candidate or whatever it is you're campaigning for that are positives that you can build upon and that you can really harness to help to put your campaign in the best position. But what are also some of the arguments against your candidate or whatever it is you're campaigning for, so that you can watch out for, okay, this is a point of attack they're going to use against whatever it is you're campaigning for, and say, this is why you shouldn't vote for this person or for this issue. Opportunities are more looking at the opposition and saying, okay, we can attack them on this. And then threats are more like, what are their strengths that they can use to their advantage, and how do you mitigate those? So it's a similar case with legislative interpretive tools. You look at the strengths and weaknesses of the bill or law that you support, and you look at the opportunities and threats from the opposition, what arguments they have on their side, for their side, and against your side. And then the fourth reason that I'm going to cover that you should know how to interpret legislation is that you're less likely to be hoodwinked by partisan, ideological, or other biased interests who try to bend laws to suit their interests and convince you of their beliefs. So there are several things that they use against you or try to use against you. One, it's that information related to laws and legislation is usually not readily accessible or easily understandable. That's partly why I even made this episode in the first place, so that this stuff can be more accessible and understandable, so that you kind of know how these disputes about how to interpret laws happen. Another thing that these biased interests try to use against you is that even if people know how to read and research, they don't often have that much time to devote to it. So they can't really spend the time to go look for this information. So sometimes they have to rely on somebody to tell them what to think, especially if it's somebody they trust. And then number three, a lot of information is competing for your time. There's a lot of stimuli, and not all of it is political. Some things are just, maybe it's sports. I love sports. I love video games. I have a whole bunch of things that are competing for my time too. All of us have a whole bunch of things that are trying to compete for our attention, or some of us are raising kids or have a spouse or whatever other interests there are out there. A lot of this stuff is competing for your time, which can overwhelm you and make you just simply rely on sources you trust, sort of like what we talked about before. But it's not with the knowing, even if you know how to read and research, but it might not even be because you just don't have the time to do it. You might just feel like, I can't handle all the stimuli being thrown at me. Somebody just tell me what to think about this piece of legislation. And even if it's not necessarily like a specific source that they're going to tell them what to think, they might just hear arguments and say, okay, this one sounds like it makes the most sense, I'm going to go with that. But they don't necessarily look at the information themselves. Now, it is true that some of these special interests really do believe what they are telling you. It's not all nefarious, trying to pull the wool over your eyes. But for others, it is purely for their political gain that they try to convince you of their side. So they try to say, well, no, this is what this law actually means, and this is why you should believe it. And they might have an argument on their side, they might not. But these are people that are trying to win policy battles in legislatures, elections, and public opinion polling. So whenever people are that heavily involved in politics and trying to tell you this is what this legislation means, you should take it with a grain of salt, because they're trying to tell you something so that they win. Doesn't mean that you shouldn't listen to them at all, but it does mean that you should be careful how much you trust other opinions. When you have the time and when you have the capability, it is always best to research the information yourself and come to your own conclusion, which doesn't necessarily mean that you won't be subject to bias that way also, but it's generally a good policy to try to look at laws and legislation for yourself. But it's hard. It takes a lot of time and effort to do that. And that's a big reason why I even made this podcast in the first place, to try to help make that a lot easier to deal with. Try to put this information in one place so that you're better able to inform yourself. Not just me inform you, but for you to inform yourself. So I hope that I succeed in that endeavor, not just with this episode, but with all that I do. But that is going to wrap things up for today's episode. As always, thank you so much for listening and tuning in. Please like, comment, subscribe, and share the podcast on YouTube, on Spotify, on Apple Podcasts. And for this episode in particular, I will plug that webinar that I do again that is about helping or being able to read legislation to best serve your clients or yourself if you have legislation that you particularly care about, or even if you're trying to craft legislation yourself. Knowing these interpretive tools can really help you in those endeavors to try to, A, make the best policy, but B, also succeed in making it reality. But other than that, my 5-day educational email course about how to more effectively mitigate political polarization, particularly the mistakes that we make that unintentionally inflame polarization and how to fix those mistakes. My Facebook, Paul Rader, author and speaker. My LinkedIn profile, which is simply Paul Rader. Medium.com, when I write on from time to time. My email, paulraderwrites@gmail.com. My website, paulrader.org. And my book on Amazon, Why Independents Rarely Win Elections and How They Can Become More Competitive. You can buy that in ebook and paperback format. But that is going to wrap things up for today. So thank you so much again for listening, and we'll see you next time.